Scotty, our topic today is civil claims against pedophiles and their enablers. And as you know, most of the time when somebody is the victim of a sex crime, a child, they think they're just dealing with a criminal case. What we do is civil work, and yet we've handled a number of these over the years.
Yeah, and one of the things that may be confusing about that is when you say enabler, I really think about a failure to protect in a lot of places, because sometimes what you have is you have this terrible, terrible actor who's the pedophile, and hopefully he or she is being prosecuted to the full extent of the law. But what we don't recognize a lot of times is that there's somebody else who maybe allowed that person to have access or didn't supervise the children or didn't supervise the pedophile. And so it doesn't have to be an enabler. It can also be somebody who just failed to protect.
Failed to protect can, as you point out, come in a number of different contexts. It can be failure to protect in the church. It can be failure to protect in an organization that is geared to children. It can be a spouse or significant other who's failed to protect, or a parent who's failed to protect against a step-parent. We see in many different type situations.
Yeah, and some of those have made the news recently. And unfortunately, sex crimes can happen anywhere at any time. But we do see in the news lately with whether it's the priests in the Catholic Church or some of the leaders in the Boy Scouts. But oftentimes the victim is taken advantage of because there's been usually an adult male placed in a position of power or authority over them and then allowed some alone time and access.
We see this from, oddly enough and sadly enough, from little ones, 3 or 4 or 5 years old, all the way up to 17 years old, where they're being taken advantage of by somebody that is in power and that they're vulnerable to.
Well, much older than that. We're starting to see a whole lot of the elder abuse cases as well, where you got somebody who's dependent and they really can't defend themselves who are in a nursing home or in a care facility, for example. And so I don't think we want to stop at 17. It could be all the way up to 97.
Yeah, especially in situations where someone doesn't have the ability to report, may not be able to talk, may have brain injuries of some type that make them incapacitated. If we step back at this, I can't think of something more awful for the type of work we do, more awful than the brutalization of someone who is at their most vulnerable, whether they're disabled or whether they're young.
I agree with that. And not only the brutalization, but also the betrayal of trust. A lot of times, for example, if I have a loved one who needs care in a facility, whether it's a little child or whether it's an elderly adult, I'm placing my trust and my faith in them that they will care for my loved one. And rather than even provide the basic care, they assault them, sometimes sexually, sometimes physically. And I think that's one of the things where we can help bring some justice to that situation. And there are a lot of times where I feel like I'm on the right side of things. Pretty much every case that we take, I like to think that we're on the right side of things. But if we spend our time and our money and our energies and our efforts as a law firm to try and hold people accountable who have victimized somebody who's had, they're basically placed in their care, I think that's where we ought to be focusing.
So one thing we should talk about out of the gate here is, why is it that there's even a civil claim aspect to this? Well, why isn't this just a criminal issue? I mean, if a child's raped or if somebody that's disabled is assaulted, why aren't these matters just taken care of in criminal courts?
Well, I almost chuckle a little bit because it's not an either or. And my cynical answer is because sometimes the prosecutor's office needs help. Many times we have law enforcement and prosecutor's office and investigators who are overworked and underpaid. Whereas sometimes if we can get involved, then we can do some of the legwork that then pushes them or encourages them or provides them with the information and the opportunity to go ahead and pursue a case that otherwise maybe would have been on the back burner or not been able to be investigated at all. And so I think a lot of times people think about it as an either or, a civil or a criminal, but it's really both.
Well, so again, we've had the privilege of talking with a number of people over the years we've been doing this, and I'm still surprised at how many sick people are out there that can do these crimes. But let's separate out the part where maybe there is a criminal prosecution that's being looked at, but there's not been a conviction, there's not been a guilty plea yet, versus those where they have been able to secure evidence and they've either gotten a guilty plea or they've convicted. Let's start with the first one. first of all, if somebody comes to us and they're saying, this happened to my 7-year-old, and we've reported it to the police and they're investigating it, but they're telling us they're not sure they've got the type of evidence they need. What can we do for those folks?
Well, a lot of times we can help them get answers, because many times we'll talk with folks and they're just not getting good information about why this claim can't be pursued or why there isn't enough evidence. And in the best of cases, it's because nothing really happened. They had some child who reported and they said, hey, I think so-and-so did this to me. And then the officers investigated and they decided that nothing really happened, but there hasn't been a good explanation. And that's what we hope for, is that there is, in fact, no actual crime or victimization of a child. Unfortunately, too often that's not what happens, and that there really is, but there hasn't been either an adequate law investigation or adequate evidence. And so many times then and there, we can go ahead and investigate for that family to try and determine what did happen and use our expertise and our resources and go out and gather that additional information, which may then result in the prosecution going forward.
And I know you're saying the same thing. What I always want to believe the parent and the child if the child is reporting something.
Right.
And if a child's going to report it, unfortunately, many times several days have passed before they report it. And depending on the level of assault that's occurred, there may not be any DNA evidence that still exists at a certain point in time. The prosecutors look at that and they think, well, how are we going to prove this beyond a reasonable doubt? We don't have the same issues in the civil side, right?
Right. I mean, we have the same problem with having to prove what happens. And unfortunately, a lot of times now with some of the TV shows that people think there's got to be DNA, there's got to be evidence, and there's got to be some way to prove it, because that's what we see on CSI or NCIS or whatever the current show is. But also the difference that I think you're mentioning is the prosecution has to prove beyond a reasonable doubt, whereas in the civil case, we're more likely than not. And I'm probably dating myself now, but the O.J. Simpson trial is one I always think of, is where, in the criminal case, he was acquitted. And then in the civil case, he was actually had a judgment entered against him. And that's mainly because of the different burdens. I think that the jury could have listened to all the same evidence and said, we have a couple of doubts about whether or not O.J. Simpson did it, and so we can't convict him under the instructions we've given, but we're pretty darn sure he did it. And so in a civil case, he had a judgment entered against him. Is that what you're talking about?
It is. And part of what we do with the civil claim is we're going to investigate the claim. Now, there's typically going to have been some sort of law enforcement investigation, but they have certain limits of what they can do within their investigation that we don't necessarily have. In other words, somebody can take the Fifth Amendment and not talk to law enforcement, or they can refuse to discuss it if they're not considered to be the perpetrator of the crime. They can just refuse to discuss it, and probably the law enforcement entity has limited powers of what they can do under that circumstance. If we bring a civil claim and a lawsuit's filed, then they're going to answer our questions, most likely, through a deposition process. That information then can later get to law enforcement and help beef up whatever evidence they're needing in order to bring the claim. And we have seen times where actually the loser that committed the crime confessed to us or somebody else during that process.
Well, the other piece of it, kind of the advantage that we have, is we get to step back and look at the bigger picture. And a lot of times what I've noticed is that law enforcement or the prosecutor's office is focused on this particular singular event. And so what we can do is we can go out and we can look at the other investigatory agencies and what their efforts have been and talk with the family and potential other victims. And we can sort of put this together into a broader picture. We had one claim not too long ago where we found a later victim that was unknown, or at least not followed up on by law enforcement. And I think that being able to step back and take that broader picture can help find evidence that law enforcement doesn't find, but more importantly, find where the flaws in the system are to prevent this kind of thing. And that's what I want to talk about real quickly, is why we bring these claims isn't just to try and get justice for little Timmy or Betty or whoever the child victim is, but it's also to try and prevent this kind of thing from happening in the future if there's a way we can identify a system problem that can then be put in place.
For sure. And, we see this isn't a surprise to anybody. If somebody's not held accountable, it seems to happen over and over and over again. And that's particularly true with pedophiles. If they're not brought to account, held responsible, it unfortunately seems to embolden them to go ahead and act out. And sometimes those actions get worse each time.
Well, again, not to paint the Catholic Church or any organization in a negative light, but you have seen sometimes where there has been an allegation and investigation, and then that person's been transferred to a different location, and then you have another allegation in that location. And so absolutely, if we collectively as society aren't doing something to stop it, we know that these crimes will be repeated. We know that these offenses against children will continue to happen. And I think that part of our moral obligation, if you will, is to make sure we do our part to make sure that it doesn't happen.
Well, so gathering evidence, we don't have situations where we can compel someone typically to give up DNA evidence. That oftentimes either will have already been accomplished by law enforcement or isn't going to be able to be accomplished. But within the scope of what powers we do have, with subpoena powers, with the ability to take depositions under oath, we are able to confront bad actors with events that occurred, and they have to answer the questions that we're asking them in a way that makes them probably very uncomfortable at times. But part of our training is to interrogate, and that's the distinct difference sometimes we see within law enforcement is, especially in some of the rural areas, they really don't have a trained interrogator, somebody that really knows how to go around cross-examining someone and getting answers.
Right. And I think that it's really important to have that skill set. And it doesn't necessarily have to be you or me. I think that we're skilled and well able to do it. But there are larger jurisdictions that you mentioned who have trained investigators, like sexual crime investigators. We have a local resource here, the Children's Center, who will do an interview to a child. And one of the things that we have learned over the years is that if a random law enforcement person asks a child what happened, they can ask it in a way that destroys any real evidentiary use for that. And part of what you and I have now, over the last however many decades we've been doing this, we know how to ask certain questions, not just to get to the truth out of a potential perpetrator, but also how not to screw up the testimony of the victim or the family. And the other thing that maybe we should throw in here too is we have the ability, the resources, and the team to bring in experts who can do these things where you and I may not have the skills either. But again, we can bring in those experts who can then give the information to law enforcement or help with a civil claim. And I'm reminded again of kind of what you talked about early on. There may be evidence, medical evidence, for example, that is taken but not acted upon. And I can't remember the number of cases where we've had to bring in a medical expert who's looked at that very same evidence that was collected, but nobody ever did anything with it, or the person who did something with it was a law enforcement personnel. And so if you bring in a medical expert who can see bruising, or who can see this type of a fracture, or who can see this kind of a cut in an intimate area of a young girl, that changes the context. And that can be, again, the linchpin in the future case.
One thing I know that folks worry about if they're thinking about either bringing a criminal prosecution or coming to talk to civil lawyers, and they've got a little one that's already in terrible pain emotionally and sometimes physically from what's happened, is how do we protect our little one from this process that we're thinking about doing? Why don't you address that? Well,
I think it's a great concern. One of the things that does happen now on the criminal side is you can have this confrontation clause, is we have the right to basically confront our accusers. And so the criminal case can have some concerns about how do we protect the child, how do we not make the child sit across the table from the person they're accusing of doing horrible things to them. On our side, we can usually prevent that. We can usually use some sort of a forensic interview as a substitute for that. We can have somebody who speaks for the child. The child can have a GAL appointed who will help present their evidence to the court. And very rarely, if you have a child of a tender years, someone who's very young, usually they'll never ever have to be in the same place as the perpetrator. Now, as you get older, if you have a victim who is of age and of capable mental mindset, that's a different story. And oftentimes you do have to have them at least show up where the defendant can be present. But we, at the civil side, have a great opportunity to protect the child from that. That doesn't mean there's not an emotional cost for the kid to go through it. And that's something that I know you and I and the rest of the firm here takes into account whenever we're trying to think about going forward with the cases. We don't want to subject the child to unnecessary harm. We don't want them to go through a process that isn't going to benefit them and isn't going to protect others. And so we do keep that in mind. But the nice thing is, if parents or loved ones who have potential claims like this, if they want to come and talk with us about it, we'll talk to them freely and say, here's kind of what you're looking at. Here's kind of the emotional turmoil and the cost and the time investment. And then we can work with them to decide if it is something they want to pursue. But I think the point I want to get across to anybody who's listening to this is, if you have this situation, it's free to come and talk with us. It's free to discuss with us kind of how this might impact you and your family and your loved one, and what good will it do? Because I think that's the conversation that needs to happen.
You mentioned earlier, one of the general goods is that it hopefully can create some kind of accountability where the person's not doing it over and over again, being reinforced and being emboldened. But we ought to mention there's a couple of different things in the civil side from the criminal side. In the civil side, nobody goes to prison. Right. Criminal side, we want the pedophile, especially if it's a repeat offender, especially if the actions have been physically violent, we want them to be in prison. So the ideal is that if the conviction hasn't already taken place yet, we're securing information that can help with that process on the criminal side, even though we're not going to be the ones that make those decisions ultimately. Absolutely.
And you and I both taken depositions, and the first thing we do with it when we get the transcript back is send it over to the prosecutor's office and says, hey, you may want to look at this. You may want to look at these pages, because this is going to give you information that can help you put that SOB away. And I think that's key.
Just make one example while we're talking about it. And to protect the privacy of the people involved, I'm not going to be terribly specific, but I'm going to give the general outline of a case that we handled a number of years ago. And it involved a disabled young man. And when we first took the case in, we didn't know exactly what had happened because he was in assisted living at the time. And we just knew that he had had an intra-abdominal bleed that occurred under the care of somebody else. And so we were investigating it. As that investigation moved forward, it began to look like there was an action that had taken place of some type that had caused it, rather than it being some internal thing inside this fellow's body that had caused it. We sued the caregiver, took depositions, and as that process began to unfold, he ultimately confessed to somebody, and he's now in prison for his crime. But initially, we didn't even have the evidence that a crime had been committed. It took a level of investigation to get there, and that young man that was the plaintiff in the case was not able to speak himself about what had happened because of his own disabilities.
And that's one of the things that you hear about now too often, is somebody who, for one reason or another, maybe they're too young, or maybe they're disabled, or maybe they're too elderly, or they have dementia or something like that, where they can't communicate. And those are the people who end up being victimized because they're vulnerable and nobody's going to be able to stop the perpetrator. You hear a little bit about the one recently in the news where the lady had been in the coma and she ends up pregnant. I mean, it's the same kind of thing, as you've got somebody who's unable to protect themselves. And you hope that there's some accountability there, whether it's both criminal or civil, but there is a system breakdown that allows these folks who are completely dependent to be victimized, and for people not to know about it and not be able to hold others accountable.
So then we've got the other type of case where there has been a conviction already, has been sufficient evidence to cause somebody to either confess within the criminal part, and then folks are coming to us to talk about, well, should we pursue a civil claim? So that area is one where, the criminal part's already been taken care of. What good is it going to do anybody to bring a civil claim under that context?
Well, a lot of reasons why there still may be good to be done there, and part of it has to do with how it is that criminal conviction arose. And for example, if it is a daycare teacher who was molesting a child, I think it's great that daycare teacher has now gone to prison and that the kids in that particular setting are protected because the perpetrator's gone. The problem is, if it's just the criminal case, I'm not sure there's a sufficient level of awareness in the community about what kinds of things need to happen to prevent this. Because you and I both know that there are policies that you can put into place that are going to reduce the chance that you put a pedophile in contact with a child in such a way that they can continue to victimize. And so there are good policies that can be put in place in daycares. And sometimes, even if you hold the particular pedophile accountable, if the daycare isn't also held accountable for not following policies, or for not putting policies into place, or for not doing a background check to figure out they're hiring pedophiles in the first place, then you're just going to have the same action repeat with a new offender. And so my goal is to stop the system error and to stop that systemic problem from occurring again, because I don't want to just make sure that one perpetrator goes to jail and another. I want to stop these perpetrators from having access to our kids in the first place. And so I think that's probably, for me, the best example.
So policy changes, public awareness. What we're ultimately able to do is really limited to just bringing a money damages claim. But the ripple effect of that, the attention given to it, I think is what leads to the policy changes or the public awareness of it. Let's just give one example. The Boy Scouts, which everybody loves and thinks, this is a great organization for us to send our kids to, our young ones to go out to camps. Recent article just published. This is an audit that was done by the Boy Scouts of their own records by a professor from the University of Virginia who did this study. 7,819 scout leaders. These are the leaders that were responsible for abuse or assault on children. 12,254 victims of that abuse. So we had a related organization, not the Boy Scouts, a related organization where we had a case where they were this fellow was taking care of an autistic kid as part of the organizational scheme that they had put in place. And we later learned that this young autistic kid had been sexually assaulted by this person who was supposed to be looking up to and was taking care of him. So by bringing the claim, even though this fellow ultimately confessed and was going to suffer criminal penalties, by bringing the claim, one hopes and believes, like one hopes and believes would be true of the Boy Scouts, that there will be policy changes put in place, better oversight, maybe screening that would be done to reveal who these people are that would have proclivities for it, because usually if they're done it once, they've done it before. And hopefully saving other children from going through the same process, even though that particular claim is limited to money damages in terms of what we can ultimately accomplish on the civil side.
Well, and as a parent, I'd want to know, because I think too often as parents, we think I'm going to drop my child at this daycare facility or with this organization. And I'd certainly want to know if there are tens of thousands of reports of abuse that aren't being communicated to me. And so sometimes that heightened awareness can not only lead to policy changes, but also lead to action changes of those. I mean, I'm going to ask a lot more questions. I'm going to send my kid somewhere where there's that kind of thing going on. The other side of it, though, is sort of in between. And that's these claims where people may not know exactly how to deal with it. And what I'm thinking about are some of these claims where you and I have had where we got somebody in authority who has taken advantage of that authority, and it's not as clear to the average listener that there's a problem going on. So I'm thinking about the school teacher who ends up having sex with a 16-and-a-half-year-old. To me, obviously, there's a problem there, but to the prosecutor, that's not the kind of thing that they're going to be jumping up and down to go prosecute. So statutory rape kinds of things, or if somebody's going through counseling and they have a therapist who then convinces them to enter into a sexual relationship with them, or a doctor. And a lot of times where we have these disparities of power, I mean, you think about it in sexual harassment claims, which are terrible too, and we handle those, as you know, but these claims where there is such a power difference between a therapist, a doctor, a teacher, and a student or somebody who's in their care, where there's really not a good way for them to consent, and they take advantage of them. And a lot of times it's the same kind of grooming activity that we see with molesters. And I think a lot of times we need to step in those situations because law enforcement won't or can't.
You brought up a number of examples, some of which are with people who can't consent because they're not old enough yet, even though theoretically they're willing participants, they're just not old enough to be. And others where because of manipulation by somebody in power, even though they may be adults themselves, the victims, agreeing or acquiescing to what the person in power wants. All of which lead to civil claims. But one thing that we're conscious of when we bring a civil claim, because at the end of the claim, although we've been talking about other non-monetary type of ways that it makes a difference in the system, our civil claim is ultimately going to be one where we're going to either collect on money damages or we're not. Right. And one of the things as lawyers we're thinking about if we're going to put somebody through that process is this a claim that we can ultimately collect on money damages.
Yeah, and I think a lot of people think that there isn't a way to do that, but you and I have been creative or persistent over the years in finding other ways, and that's one of the reasons why I mentioned the failure to protect early on, is a lot of times there are exclusions from having to pay for insurance policies, for example, for the bad acts of the bad actor. But oftentimes there is negligent acts where somebody fails to protect somebody and they didn't know there was a bad act going on, but they didn't supervise the child well enough and they allowed the bad act to happen through negligence. And although there are laws now that are trying to change that, most of the time we can get creative and find insurance coverage that can go ahead and cover on that. And the other thing that's been interesting for us is sometimes the organizations will pay, or we've had a few individuals who are wealthy enough to pay. And so a lot of times we can provide some financial relief to the family and to the victim and pay for therapy or future care needs or what have you. And so again, it's free to talk to us about that. If somebody has a potential claim, we can explore whether or not there is a way to have some financial recovery. And so whether there is or there's not, there's always the potential for policy change. So I invite anybody who has this kind of concern to come and visit with us.
Let's take a break, and then we'll come back and wrap up. At Johnson, Vorhees, and Martucci, we handle serious injury and wrongful death claims.
Proving the owner knew or could have known of the dangerous condition is something that is important.
A wrongful death case springs from a negligence claim of some type.
Any good personal injury attorney will give you a free consultation.
But just because you've been injured on someone else's property, such as fallen, doesn't mean you have a case.
If you're wondering whether or not you need to talk to an attorney about a car wreck, the answer is yes, you do.
Three specific things I want for the two of us to address before we close up. One is going to be where the church is involved and what the laws in Missouri do or don't do where that's concerned. Secondly, what we call negligent security type claims, where some entity is responsible for securing their premises and they haven't and somebody gets assaulted. And then third, and oddly enough and sadly enough, this is maybe the most common, and that's where a relative or even a parent or step-parent is the one responsible for it. Let's take the last one first.
So unfortunately, we know that most of the time, especially child victim cases, that the child is victimized by somebody who's close to them, usually a family relative or family friend, and oftentimes a step-parent. And those situations can get really tough sometimes on prosecutors because the other person in the home often doesn't want to believe that. And so if you have, for example, a mother who's got a stepfather that she's in love with, she doesn't want to believe that he could be the kind of person who would be victimizing her daughter. And so a lot of times it's that sort of situation that gives rise to the failure to protect claim that I was talking about, where the mom certainly only wants what's best for her daughter, but gets blinded, has a blind spot for the stepfather in this situation. And it's those kinds of situations where later on we can sometimes help address the situation by coming in and say, well, here are some of the things that have gone on. And oftentimes we're going to get involved way after the fact, but hopefully we can bring awareness to situations so that others who are in similar situations can look out for some of the warning signs where you have a step-parent who's being too intimate with the new stepdaughter, who is now spending a lot of alone time, who is now trying to get involved in the bathing routines and those kinds of things, because very often we see grooming activities long before there's any overt sexual act. And that's the kind of thing that I hope we can raise some awareness about. It's also one of the places where we have been somewhat successful in securing homeowners insurance, because the mom certainly never did anything bad and didn't want anything bad to happen. She just didn't know or didn't have enough reason to suspect, or had the blind spot, like I mentioned, so that she didn't protect her child, and she was negligent in supervising or negligent in how she conducted, who she let around her child. The other thing that we see a lot of times is somewhat distant relatives, where you've got an uncle, for example, where maybe that uncle has had a history and nobody knew about it. I can think of at least two cases that you and I worked on where others in the family knew that an uncle or a grandpa or somebody had a history of this, but they never bothered to tell their family members when uncle was going to come and stay with them. And to me, that's just mind-boggling. I don't understand that. But if that's the case, where somebody knows, has actual knowledge that this person has perpetrated in the past and then doesn't tell somebody, it can often give rise to claims.
Yeah, so negligence. What really gets me is the times when a person is just willingly blind to things that they should be knowing is going on, or warning signs that ought to be red flags. Again, we've seen these too many times where anybody that is being ordinarily reasonable, which is what our standard is, chooses to ignore warning signs, and then a child gets hurt. And again, whether it's a new spouse, and then we later learn about it from the ex-spouse, who's being told by their daughter, my stepdad just did this to me, that sort of thing, or whether it's a grandpa or an uncle or aunt. It's infuriating, it's reprehensible, but you can understand the psyche sometimes in the role of the negligent party, not wanting to believe it, yet having all the warning signs there. So that's one thing we're talking about.
Well, and on that line, it's probably a good transition to some of the organizations, because to me, while I don't exactly understand it, I sort of almost get it. Whenever you got a loved one in a situation where you don't want to think badly about it. But in some of these organizations, there's an active cover-up, and they're actually putting their own organizational publicity or well-being above protecting kids. And that's the one that really ticks me off. It's the nicest way I can say that.
Well, and that can be in the context of a business who has a duty of taking care of kids or disabled people. It can also be in the context of a business that that allows people to come into their establishment where they have vulnerable people there. So, for instance, a hospital situation, and we saw one of these recently where a young lady, just barely 11 or 12 years old, was sexually assaulted by somebody in the hospital setting. And so there is a level of security that's needed anytime you're going to allow anybody to come into your establishment and you've got vulnerable people there. A level of security and attention that needs to be brought to what's happening in your surrounding. So again, we're talking negligence here. These entities aren't intending for any of their customers or clients to be hurt, but they're just not being watchful sufficiently for folks that are vulnerable when all comers are allowed to come in.
We also see that in some of these facilities that are designed to help troubled youth. Kind of your comment about vulnerable. Well, it's also, if we know, for example, that there are a number of people in a mental health facility, for example, some of which have had allegations or even substantiated cases of perpetration, they need to be watched, and they need to make sure that they don't have access to others. And that's one of the things that, again, just is crazy to me, is sometimes you'll have a school or you'll have an entity that knows that, little Jimmy, for just a made-up name, he has acted out in the past, whether he's an actual pedophile or he's acting out because he was a victim of abuse, it doesn't matter. But then you place him in a position where he's left alone with other younger children. And to me, again, that's just insane. And so hopefully, if we can hold some of those entities that allow that access, if we can hold them accountable, then they won't do that again. And again, a lot of times we see this where one child has been the victim, and then he or she turns around and victimizes another child, and they're all too young to realize what's going on. But there are adults in that situation who could put in practices and policies and people to prevent that. And that's where I think we can come in and help.
So last topic on this issue is where the church is concerned. And you and I looked at a case that wasn't a Catholic church case a number of years ago, where a pastor, a Pentecostal pastor, I believe, was supposedly babysitting for a child, and he took her into a place in the home where he apparently was able to have a level of privacy, even though his wife was still in the home at the time, and ends up raping her. And it happened over a number of occasions. So one thing that was curious to me at the time, and remains somewhat appalling, is the protections that churches are given under a First Amendment analysis in the state of Missouri against civil claims being brought against them. That somehow butchering the entanglement clause in the Constitution to suggest that because there ought to be a separation between church and state, that a civil lawsuit had not to be brought against a church, so to speak. That's, of course, been seen over and over again with the Catholic Church and some of the priest issues that you mentioned earlier. So, one thing that would be on our agenda at some point is to challenge that in the right way.
Well, and I think you're seeing some of that change as public perception changes. We've seen it with government immunity, sometimes with the schools, or we've seen it with some social workers, DFS workers. We're now seeing it with the Catholic Church, where society starts to recognize that there's a problem here that's not adequately being addressed. And so in the past, we have tried to give these people in power some level of protection from claims that we thought were harassing to them or something else. But now we realize that no, we really have to protect our children. We have to make sure that we allow this kind of accountability to make sure this doesn't happen. And I think that now we're seeing some of, for example, and I'm not bad-mouthing the Catholic Church, but we're seeing some of the knowledge that was kept from law enforcement and was kept from the public by the church about what was going on in the priesthood. And I think that's helping to drive some of these the changes and the reforms. And I'm with you. I think that we've got to continue to explore those claims. And many times we can find an exception or a way around them. But when we can't, we need to just challenge them head on. And hopefully the courts will do the right thing.
So this is a topic that, there's nothing humorous about it. This is obviously not a humorous podcast when we're talking about assaults upon children or on anybody that's incapable of taking care of defending themselves. But an important thing for folks to know about, because I don't think it automatically comes to mind when the criminal case either hits a dead end or when it's ended. I don't think it automatically hits folks' mind. Maybe there's other things that can be done to emphatically stop the bad that's occurred from this and to provide some level of hope and future for the person that's been the victim of that type of crime.
The only other thing I think we may want to add here is that oftentimes, because of our experience in dealing with problems like this, we're exposed to other professionals who can help with the healing process. And so a lot of times what you and I do to hold people accountable isn't the end of it. We then also connect the victims or the family with resources in our community who can help them to heal and to help them to process what they've gone through. Because I think too often we think about a criminal case, for example, that ends with a conviction. Well, it doesn't really. It ends with the healing of that family to the extent that they can. And I know you and I and Patrick and the rest of the firm here share the same point of view, is that we want to provide those services that can help reduce the damage or the harms that we can. And so a lot of times what we end up doing is we do connect the person as the case goes along with a therapist or with somebody who can help them process some of those things so that they can begin to heal as much as they can and put this behind them.